That is your achieve.
So, are we hearing here? Yes. Yes, Mr. Bhatia.
Plus, if in view of the matter has been settled amicably between the parties outside the court, we intend to withdraw the said matter.
Okay. Heard Mr. Bhatia, learned counsel for the appellant.
Appellants.
Appellants. Mr. Bhatia submits that the matter has been settled amicably between the parties outside the court, and as such, he is not willing to pursue this. Now, as such, the appellants are not willing to pursue this matter, then he may be permitted to withdraw the same. Accordingly, taking note of the submission of Mr. Bhatia, learned counsel for the petitioner, this RSA number 150 of 2022 is thus disposed of on withdrawal.
Much obliged.
Second promotion, item 1.
So, record is nothing.
Ma'am, please, your lord. I am appearing on behalf of B. Pass over for timing, lordship.
Which one?
I am appearing on behalf of B. lordship. Pass over for timing, lordship.
Okay.
Item 2.
May I please, your lordship. My lord, it is a landlord-tenant matter, my lord.
This
I'm
is
the
a
tenant.
revision petition.
My lord,
Revision petition.
division. I am the tenant, my lord. Both the court below held that I am a defaulter as well as bona fide requirement is in favor of the plaintiff.
Okay.
But regarding default, my lord, there was an evidence that I have tendered the rent, then I paid to the court by hide NJ case number regularly. So with respect to the defaulter part, my lord, there is a perversity is there. And so far is the default bona fide requirement is concerned, my lord. In this case, my lord, the pleaded case is that son of the plaintiff will start a art school in the shop premises where I am running a tailoring house. But evidence is that this art school is running in the first floor. I am in the ground floor. Not only I, there are other several tenants.
Okay.
So at this stage, my lord, I am only praying for notice. Let them come, my lord.
Heard Mr. S.K. Ghosh, learned counsel for the petitioner. This petition under Section 115 of the Code of Civil Procedure, read with Article 227 of the Constitution of India. The petitioner has challenged the judgment and decree dated 25/11/2025 passed by the learned civil judge senior division Nagaon entitled Appeal number 2 of 2023. It is to be noted here that by the impugned judgment and decree dated so and so, the learned civil judge senior division Nagaon hereinafter first appellate court, the appellate court has upheld the judgment and decree dated 9/12/2022 passed by the learned Munship number 1 Nagaon. In title suit number past in title suit number 58 of 2014. Come to second page.
Second page.
Title suit number
58 of 14.
is it? See? Second page.
Title suit 58 2014. Oh, sorry, two is missing, man. Sorry. 2 is missing.
The petition and the documents placed on record and also peruse the impugned judgment and decree dated 25/11/2025 passed by the learned first appellate court in title appeal number 02 of 2023 and also the judgment and decree passed by the learned Munship number 1 Nagaon in title suit number 58 of 2014. Let notice be issued to the respondents, returnable in 4 weeks. step be taken by speed post and also by usual process within a week from today. Rest is shall call for the record from the learned courts below. This is the matter after 4 weeks.
My lord, interim prayer is there.
Let the other side appear. Interim
Yes.
pair of the petitioner will be considered on next date on
Yes.
appearance of the other side.
Second, three.
May I please, Lord, sir? What happened in this matter? In a decree of declaration where no relief of recovery of possession is there, the executing court beyond its power issued writ for recovery of possession, Lordship. If your Lordship kindly turn into
Where is the writ?
Lordship,
Where is the writ?
Lordship will find writ at page 75. Original writ at page 76 and translated copy Lordship will find at page number 75.
Page number 70.
5, Lordship. Hereby, the learned executing court directed the bailiff of the court to hand over possession of the Schedule B property, Lordship, Kho property, as mentioned in the plan and decree, evicting the judgment debtor. Whereas, if your Lordship kindly perish for a moment, the decree is purely declaratory.
No, their possession is declared in favor of the decree holder.
Yes, also handing over possession. If your Lordship kindly turn impugn order.
How the possession will be declared?
Possession was declared, that is declaratory in nature. But here is in the remaining part, if your Lordship kindly peruse, in a declaratory decree, Lordship, execution case cannot be even registered. As because this is.
No, you tell me how the possession will be declared then.
Yes, possession declared. Right title interest declared, Lordship, with possession. But no decree is there for recovery of possession with consequential relief. For executing a decree, there must be some consequential relief, Lordship. If your Lordship kindly peruse the judgment decree, Lordship, start from page number 49, type copy, and effective part, Lordship, at page 55. 55, Lordship. May I read, Lordship? What relief the learned trial court considered? 1 and 2. No recovery of possession is there. So learned executing court must be confined on this part, Lordship.
Okay, let notice go. We'll see.
Lordship, here some contradictory order is there in the execution case, Lordship. So may I pray, Lordship, to call for the case record of execution case, Lordship. Some, if your Lordship kindly.
No, you have produced the certified copy. Why record is necessary?
Lordship.
You have produced the certified copies of all the orders.
Not entire, some
You
other.
have produced all the orders.
Also there.
If necessary, we will later on consider the same.
Lordship, Lordship.
Heard, Mr. Your name, please?
Orally, Lordship.
Learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the order dated 28/5/2025, passed by the learned civil judge junior from Kamrup at Amingau in title execution case number 12 of 2014. Is to be noted here that by the impugned order dated so and so, the learned executing court has issued writ for delivery of possession of the requited land. Mr. Ali, learned counsel for the petitioner, submits that the decree was only for declaration of possession, but the learned trial court, no, executing court, by impugned order dated so and so, has issued the writ for delivery of possession. The submission of Mr. Ali, learned counsel for the petitioner, needs further consideration. At this stage, notice be issued to the respondents, returnable in 4 weeks. Step by speed post and also by usual process within a week from today. List after 4 weeks till returnable date. Execution of the
Title
execution of the writ
12 or 14, maybe.
issued on when it was issued,
Lordship.
when the writ was issued.
Yes, Lordship, direction was passed, Lordship. By impugned order. So stays utmost necessity, Lordship. Otherwise, I'm really big.
Till returnable date, execution of the writ dated 14th of May, when the writ was issued.
Lordship, the writ was submitted, if your Lordship kindly peruse the writ. It was signed on perhaps in the year 16 itself, Lordship. Thereafter, execution proceeding was dismissed twice, Lordship. Then again, by last order, the learned trial executing court again passed at page 68, Lordship, issue writ for possession of suit land. Most probably earlier writ will be reissued in view of this order. Last
Page
page
number
168, Lordship. One sentence line, last part. Issue writ for possession of suit land. The earlier writ will be reissued again.
So execution of the writ, which was directed to be issued by order dated 28/5/2025. Then state till returnable date, list after 4 weeks.
Highly applicable.
Item 5. May I please, Lordship? Lordship, let me introduce the parties in this case, Lordship. Here, Lordship, petitioner is and the respondent are husband and wife. And before your Lordship, today is the husband and the petitioner, Lordship. Due to some family dispute, Lordship, both the respondent and petitioner respondent were state aware, Lordship. And thereafter, Lordship, in the page number 22, Lordship, kindly. Page number 22, Lordship. Annexure 1.
Yes.
This is the Lordship. An application of section 7 of the Gauhati Act. This petition was filed by the petitioner for custody of the child, Lordship. With the interim prayer, Lordship, in the page number Lordship 29, Lordship.
You are for the father.
Yes, Lordship, and the father, Lordship.
But you see, in the impugned order, some observation has been made by the learned trial court.
Yes, Lordship. Yes, Lordship. Yes.
So
Yes,
if custody is to be considered considered,
Yes.
taking note of the well-being of the child,
Yes, Lordship.
can it be said that you are entitled to custody of the child?
Yes, Lordship. To that effect, Lordship, I kindly come to page number, Lordship. 65, Lordship. 65. It is a it's a Lordship, Child Rehabilitation Center. This is the report submitted by my wife, Lordship, in the trial court against as the objection, Lordship. I kindly come to page number 65, Lordship. Below, Lordship. Summary of House Trespass 3 person. May I read, Lordship? The child appears to be deeply affected by the ongoing conflict at home and conflicting comments from significant individuals. These issues have resulted in moodiness, suppression, aggressive tendencies, and confusion. The lack of positive and supportive relationship with a male figure compounds these feelings, Lordship. There is no male figure, Lordship, to interact with the child, Lordship. Mother went to the office and the child stay with the maid, Lordship, the whole day, Lordship. It is not filed by me, Lordship, filed by my wife, Lordship.
No, that's all right, but the observation of the court is disturbing. Anyway, let notice go at this instance.
Lordship, and next day fixed on 3rd of March, Lordship. Can it be a stay order? I'm just kindly praying for the stay of that procedure before.
Why?
Yeah,
Why
after
stay is necessary?
issue will fix,
So you have
Lordship.
already given the visitation right.
Yes, Lordship, that was also disturbing, Lordship. At her own will, Lordship, she's not giving me, even, Lordship, today is the Monday, yesterday, Lordship, she won't allow me to for visitation, Lordship.
Let notice go at this instance. Let the other side appear. After hearing both the parties, we will consider your pair. Heard, Mr.
Be seen, Lord.
Learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the order dated 9/1/2026 passed in Miss G case number 04 of 2023 by the learned additional district judge Dorong and Mongoldoy. It is to be noted here that by the impugned order dated so and so, the learned additional district judge Dorong Mongoldoy has rejected the pair made by the petitioner in petition number 784 of 2024 and the petition number 2601 of 2025. Peruse the petition and the documents placed on record and also peruse the order, impugned order dated 9/1/2026. Let notice be issued to the respondents, returnable in.
One more thing, Lordship. Lordship, kindly come to page number 43, Lordship.
Page number?
43, Lordship.
Mm.
Annexure 7, Lordship.
Mm.
That is the order of 8/1/2026, Lordship. There was no any prior direction to the respondent to produce the child before the court to record his statement, Lordship. Everything are done by Honorable Lordship. There is no proper direction, Lordship. They brought the everything in happened in the within the no direction, Lordship. Only for that reason, Lordship. Kindly interim may prayer, Lordship. Let
No, your petition is rejected. Then what purpose will be served by staying the further proceeding?
our Lordship, no direction was given, and they just brought it on and on, Lordship, and they just get
No, visitation right is given to you.
even Lordship. My mother is also a Lordship. It's all over 84 years, Lordship. Still, she could not access her grandchild, Lordship.
You see this paragraph number 7 of the order.
Yes, Lord.
The last part is disturbing.
Yes, Lord. Yes, Lord. His father teaches him bad thing, Lordship.
Mm.
Yes, Lordship. For that reason, I have placed a pen drive, a video recording, Lordship. That is a stigma carrying on me, Lordship. Since that day, Lordship.
No, this is the observation by the court. Court has recorded the same after interaction with the child.
Yes, Lordship. But yes, Lordship, to clarify my that statement, Lordship, I have given a Lordship video recording before your Lordship via pen drive, Lordship. So I'm carrying a that stigma, Lordship, from that day, Lordship.
Returnable and forex. Step by speed post and also by usual process within our from today. List the matter. After 4 weeks, interim pair of the petitioner will be considered on next returnable date.
Deep Lordship.
Number 6.
May it please your lordship. By the impugned order, lordship, amendment was allowed. I'm challenging that your lordship. In this case, I am the defendant.
What is this? The amendment was allowed?
It was pre-trial stage. It was pre-trial
Pre-trial
stage.
stage.
And on that aspect only, since trial has not commenced, the amendment was allowed. And another aspect, that the nature and character of the suit was changed. That was not
How?
done. in-
How?
Lordship may see the initial plaint at annexure 1 starts from page 11.
Mm.
Page 16 is the prayer, your lordship. I am the defendant number 1 in the suit. There is another defendant, defendant number 2.
Mm.
Admittedly, plaintiff is the landlord, your lordship.
Mm.
Prayer is in page 16.
Mm.
A declaration was sought that I am the tenant. And a declaration was sought that defendant number 2 is a stranger and defendant number 2 is to be evicted from the suit premises. There was no prayer for evicting me, your lordship, because I was paying rent and everything was in my favor, your lordship. Another person has forcefully entered and defendant number 2 in prayer B, your lordship.
No, you say, come to page number 56,
Lordship.
where the trial court
Lordship.
has recorded a finding that merely because additional relief of eviction, area rent, and pendant light, future rent
Lordship.
have been incorporated, it cannot be said that the nature of the suit has been
Has been
changed.
changed. Now, your
The
lordship.
foundational facts relating to ownership, tenancy, and possession of the suit premises remain the same.
Lordship. Here in this case, as I have shown your lordship from page 16, your lordship, the prayer was primarily directed against defendant number 2. Now coming to the amendment petition at annexure 4, page 39,
Mm.
after filing of the WS,
Mm.
the plaintiff, your lordship, has prayed for my eviction, has converted the entire suit into an eviction suit, your lordship.
Mm.
It was never a suit for eviction of the defendant. It was a suit. It was not a suit under Assam Urban Areas Rent Control Act.
What is the purpose of this amendment? To avoid multiplicity of suit.
Multiplicity of suit.
Then-
In this aspect, your lordship, there is another suit pending between the defendant number 1 and defendant number
And
2.
you say there is a decision of Supreme Court. This
Initially, the suit
2022 perhaps 2022 SSC online SSA 1128. That LIC
LIC housing.
LIC case.
There is a decision, your
So
lordship, but
there it has been held that all amendments shall be allowed if the same is found to be necessary for proper adjudication of the dispute
lordship,
between the parties.
lordship, that can be distinguished if it may be taken up next week, your lordship. I will try to convince upon your lordship how that judgment is not
Hmm?
coming into the way in this case, your lordship. Because this suit was never a suit under Assam Urban Areas Rent Control Act. This was for eviction of the defendant number 2, who is not a tenant.
Not a?
Not a tenant. As per their prayer, defendant number 2 is a stranger to the plaintiff, stranger to the landlord tenant.
Then how he has been arraigned as a defendant?
He had forcefully entered into a portion of the premises there's a dispute between defendant number 1 and 2.
Mm.
And forcefully he has occupied a portion of the shop room. And after filing of the WS, the prayer, which was for eviction of defendant number 2 only, who is not a tenant, has been converted.
You have enclosed the plaint and written statement here
Yes, Your Lordship.
and the amendment petition.
Yes, Your Lordship. Plaint is at page 11. And what I'm trying to show is from page 16,
Mm.
the prayer of the plaints.
Mm.
They prayed for a declaration in A, declaration that the plaintiff is the owner and landlord of the defendant number 1, which I agree. And defendant number 1 is a tenant with respect to the suit premises. B is declaration that the defendant number 2 is a stranger to the plaintiff and he has no right, interest or possession with respect of the suit premises. And if she is found in possession, a decree for her eviction from the suit premises. This also I am agreeing to, Your Lordship.
Mm.
C, declaration that the defendants have no right to change the nature and character. We are not changing the nature and character, Your Lordship.
No,
So
no,
these
these are the issues to be adjudicated after hearing both the parties.
Both the parties. This was the
After trial.
initial suit, Your Lordship.
Mm.
After amendment, Your Lordship,
Mm.
this suit, which was never directed against the defendant number 1, all the prayers were against the defendant number 2 only.
No, no, here you see defendants. Number C pair,
Yes, Your Lordship.
that the
Nature and
defendants have no right.
Yes, Your Lordship.
Number 4, that is also defendants.
Yes, Your Lordship. And after amendment, Your Lordship, which is at paragraph annexure 4, Your Lordship, the amendment petition
Ah,
starts from page 39.
what are the pairs?
The amendment sought is an extensive amendment, Your Lordship. Even the valuation and everything is changed. Thereafter, prayers were incorporated at page 43.
Mm. These are additional pair.
Additional prayers. Your Lordship, these are new prayers, Your Lordship. And in this aspect, another paragraph, Your Lordship, which was sought to be incorporated.
After amendment, they have prayed these additional pairs.
At
They
page
have.
41 also, Your Lordship.
Mm.
Page 41. As from the initial prayers, Your Lordship, there is no dispute of area rent or I am not a tenant. There was not there. Para 3A at page 41. The defendant number 1, that is me, Shahzada Parvez, used to send rent of the suit premises through Nasim Akhtar. That is the defendant number 2's husband. And others. Nasim, they have entangled him. Initially, they said that Nasim Akhtar's wife is alien to the suit premises. They have prayed that she is alien.
Defendant number 2 is the wife of defendant
Nasim
number
Akhtar.
1.
No. Defendant number 2 is the wife of Nasim Akhtar, one Nasim Akhtar.
Okay.
And initially they said the defendant number 2 is alien to the suit premises. That was the admission in their initial plaint. Now in para 3A at page 41, they have made an insertion that I, defendant number 1, used to send rent of the premises through Nasim Akhtar. So an admission that was made in the initial plaint is also sought to be changed by way of this amendment. The plaint at page 11.
No, these pairs, I don't think that changes the nature and character of the suit.
Lordship, it may be taken up next week. I'll show how that judgment also will not be applicable here, the LIC judgment.
Why?
Because, Lordship, there are two aspects. One, the nature and character, which I'm harping on. Another aspect is there, if there has been a admission or an admission in a pleading, Your Lordship, that cannot be changed by way of an amendment, Your Lordship. A contrary view can pleading cannot be taken by way of an amendment, Your Lordship. At page 11, the initial plaint, they are saying defendant number 2 is have nothing to do with the suit premises. Now they have incorporated and said that I have been sending rent through them. In a way, they are accepting their possession over the suit premises, Your Lordship. And there is, in this matter, Your Lordship, there is another suit pending between the defendant number 1 and 2. And this amendment is affecting my rights in that suit as well.
Okay, you come prepared.
Lord,
The pair being made by Mr. Mukherjee, learned counsel for the petitioner, is listed on when
next week, any date.
next week.
Lord.
Item 7.
May I please, Your Lordship? My application for amendment of the plaint was rejected, Your Lordship.
When did you file the application?
Yes, in 24,
At what stage you have filed the application?
evidence stage, evidence stage.
Is it permissible in evidence stage?
Yes, here, Your Lordship, there is a criteria
Hmm.
that if the nature is not changed by amendment,
Hmm.
and when the nature is when the amendment would result in introducing new cause of action.
When you have filed a written statement?
Your Lordship,
When did you file the written statement?
amendment application.
Yes. No,
Yes.
no. In the title suit, when did you file your written statement?
Written statement, I am for plaintiff, Your Lordship.
Oh, you are plaintiff.
Yes. I'm plaintiff.
Hmm.
They have filed the written statement in twice.
Hmm.
One is in 2017 and another is 23.
23.
Yes.
And when did you file the application for amendment?
Amendment is during the pendency of the suit, we came to know that some part of the land, my suit land has been already sold out by the defendant.
No.
So,
How do you explain your due diligence in
Yes,
filing
yes,
the application?
yes, Your Lordship,
Hmm.
at page 16, here, in this case, whatever, Your Lordship, the court campus has been changed to another place during the pendency in the year 17. From Bilasipara to another place.
Hmm.
That place was 6-7 kilometers away.
Hmm.
So because of that, the Bar Association, Bilasipara Bar Association has stopped to appear this court, this campus.
Hmm.
Because of that, that court has come into the Bilasipara again in the year 2024.
Hmm.
Because of that, we could not file any application. That has been transferred in 23.
Can it, yeah. Whether in this way you can explain your due diligence?
Then I have to obtain the certified copy of each and every days.
You, Mr. Upadhyay, you see, the written statement was filed on 2nd of January 2017.
Yes, it was filed by the defendant once.
Hmm.
She died. Again, her legal heirs filed the written statement in 23.
Hmm.
2023, they have filed.
Hmm.
Your Lordship, page 31, 27 February 2023.
And this application was filed on which date?
It is in 24, Your Lordship.
24.
Date is third day of September 2024. Third day of September 2024.
24.
Only
Even,
the amendment
even
required
from
is
the second WS also there is delay. Unless you explain it, the court cannot entertain the application.
but
There is a
there is a
decision of
delay.
the Supreme Court.
Of course, but I have no other option at present, Your
So what
Lordship.
to do?
Because
How can,
if it is amendment is not allowed, then my suit will go because the cell deed is there. I have to challenge the cell deed.
How the trial court and also this court can go against the order of the Supreme Court? Okay, let notice go at this. Heard. Mr. Upadhyay, learned counsel for the petitioner in this petition under Article 227 of the Constitution of India. The petitioner has challenged the order. Dated 9/12/2025, passed in Mizze case number 132 of 2024. It is to be noted here that by impugn order dated so and so, the learned trial court has dismissed the application filed by the petitioner for amendment of the plaint. Where is the petition and the documents placed on record and also the impugn order dated 9/12/2025. Issue notice to the respondents returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. List after 4 weeks. Interim payer of the petitioner will be considered on next returnable date.
Number 8.
Obliged.
May I please, Your Lordship? Lordship, this contempt has been filed for the willful and intentional violation of a judgment and decree passed in judgment and decree dated 36/2006, passed in title suit number 240 of 2003. The suit of the petitioner was decreed, and now nearly after 18 years, the petitioner has been dispossessed from the suit land. So
No, you say after 20 years, almost 20 years,
almost 20 years.
can we entertain this contempt petition?
Yes, Lordship, because this contempt has been filed for violation of the decree of permanent injunction, and limitation for permanent injunction runs in perpetuity. Runs in perpetuity because they are still possessing over the suit land of the petitioner. So the cause of action still survives.
Heard, Miss?
V. Rai.
Learned counsel for the petitioner. No, for the applicants. This application under section 10, 11, and 12 of the Contempt of Court Act 1971, read with Article 215 of the Constitution of India, read with Rule 5(1) of the Contempt of Court, Gauhati High Court Rule 1977, is preferred by the applicant, Sri Basudev, for intentional and willful violation of the judgment and decree dated 38/6/2006, passed in title suit number 240 of 2003 by the learned civil judge, senior division number 3, Kamrup, wherein the contemnors struck defendants were permanently restrained from disturbing the petitioner's peaceful position over the Schedule A to D plot of land. Peruse the petition and the documents placed on record. And also peruse the judgment and decree dated 38/6/2006, passed in TS number 240 of 2003. Let notice be issued to the respondents returnable in 4 weeks. Step by speed post and also by usual process within a week from today. The question of maintainability is kept open. List after 4 weeks.
Deeply obliged.
Number 37.
May I please, Your Lordship? My lord, this I is filed for the correction of some mistakes which is done in the petition only, my lord. The mistake is, my lord, written Tinsikan instead of Sipsagar, my lord. The case is pending
Okay.
by
First, we have to dispose of this IA.
I, my lord.
Okay.
The first title and paragraph 11, 12, 15 and 18, some mistake is there.
Heard, Mr.
And see that.
NC does learned counsel for the applicant. This interlocutory application is preferred by the applicant for correction of inadvertent mistake that kept in typing the district as Tinsukia instead of Sibsagar in Costatal, and also middle some of the paragraph in some of the paragraphs in the middle of the transfer petition number 19 of 2006. The learned counsel for the applicant submits that the district mentioned in the Costatal ought to have been Sibsagar instead of Tinsukia. Tinsukia. But inadvertently, the same has been typed as Tinsukia in the Costatal and also in the middle paragraphs of the transfer petition. And the same are required to be corrected. Para. Having heard the submission of learned counsel for the applicant and also having gone through the transfer petition, which in bracket C number 19 of 2026, this court is inclined to allow this application. Henceforth, the district mentioned in the henceforth, Tinsukia district, as mentioned in the Costatal in middle paragraphs of the transfer petition number 19 of 2026, shall be read as Sibsagar for all purposes. In view of the order passed in the IA, Mr. Das, learned counsel for the petitioner, shall file amended Costatal, the amended petition within a period of 1 week from today.
My lord. Let it be on Monday, next Monday. Please. In the meantime, we will file our amended petition. Second case. Monday. Second March.
Monday, 2nd March.
March of
Orders.
Asal to party. Okay.
20 and 39.
20 and
20 and 13. 20 and 39.
20 and 39.
39 is for
Lordship, 39 is the I Lordship for correction of some typographical mistake in order that Lordship 4 to 26 Lordship. Lordship order is at page 9, start at page 9 Lordship. While allowing Lordship my one I 141/26 Lordship. Lordship at paragraph 7. There were 6 opposite parties, Lordship. They were directed to be implemented as per number 226 in contempt petition number 5724. This Lordship number 226 should have been 227. That only, Lordship.
2 to 7. Okay. Or Mr. P. Sharma, learned counsel for the applicant. This interlocutory application is preferred by the applicant for correction of inadvertent typographical mistake in the order dated 4/2/2026 passed by this court in IA civil number 141 of 2026, filed by the applicant in contempt civil petition number 576 of 2024. Mr. Sharma, learned counsel for the applicant, submits that in paragraph number 7 of the order dated 4/2/2026, in I civil number 141 of 2026, a direction was issued for implementing respondent contender number 226 in contempt case number 576 of 2024, and instead of 6, the said contemptors ought to have been recorded as 227. And as such, Mr. Sharma has contented to allow this application. Para. Having heard the submission of Mr. Sharma, learned counsel for the applicant, this court has carefully gone through the petition and the documents placed on the record and also perused the order dated 4/2/2026. It appears that in paragraph number 7 of the said order, direction was issued for implementing respondent contemptor numbers 2 to 6 in contempt case number 576 of 2024. But it ought to have been respondent contemptor number 2 to 7 in contempt case number 576 of 2020. Accordingly, it is provided that henceforth, in paragraph number 7, in the last line, the respondent contemptor number 226 shall be read as 227.
In the main contempt petition matter, I may be allowed to take steps to all the implicated respondents.
But Mr. Sharma, you see, in the IA number 141, whether there was any respondent as a respondent number 7.
Earlier, one respondent was there in original contempt petition, Narayan Kaur.
One respondent?
One respondent already there, Narayan Kaur.
Okay.
So in 41,
Okay.
I paid for implementing 6 lordship opposite
Okay.
parties.
Okay. In view of the order passed in IA civil number 543 of 2026, Mr. Sharma shall file amended cause title. You have filed amended cause title?
File lordship, that has been lordship. Also, registry has updated lordship.
Mr. Sharma submits that a person to the order dated. No, why? আগতে কি করলো লাইনটা? Sharma has to file the amended cause title. However, Mr. Sharma submits that he has already filed the amended cause title and the registry has updated the same. And he submits that he may be permitted to take step upon the newly pleaded respondents. Accordingly, it is provided that a step be taken by speed post and also by usual process within a week from today. List the matter after 3 weeks or 4 weeks?
After lordship, 2 weeks lordship.
After 2 weeks. After 2 weeks.
Number 22.
May I please, your lordship? As per the office noted, 22-26 steps has been taken, lordship, to the sole respondent.
Hard miss?
KLR Yanthan.
Learned counsel for the petitioner. Office note dated 2026 indicates that notice was issued to the respondent only on 2026. So list the matter after 1 week, awaiting service report upon the respondent.
Interim order may be continued,
In
Lordship.
the meantime, the registry shall treat consignment and put up one up-to-date office note in respect of service. Interim order passed earlier shall continue.
File number 23 and 24. My lord, in number 23, my lord, we have referred that to IA, my lord, for leave to file a review application, my lord. The last occasion, my lord,
IA in review application.
yes, my lord.
IA is for what purpose?
One IA for leave to file a review application, my lord.
Leave.
Yes, my lord. And my lord, last occasion, my lord, the petitioner, to
Was
file
absent.
yes, my lord. To
Yes,
file,
you were appearing for?
And for the secondary education department for response 1, 2, and 5, Lordship.
Anybody for the petitioner, you are? Respondent number? 4.
Response number 7 is a great petition also. How come nobody is there, Lordship?
yes, my lord. Oh, opposite.
Okay, बाकी respondent मेरे को माती के बोले थे। State of Assam, terms of director of pension, proper inspector of school. তাৰপিছত আৰু এই petitioner হেৰি আছে 7 read petitioner. After some time.
Yes. Item 25.
None appears. For the petitioner on call is the matter after 1 week. In the event of subsequent non-representation of the petitioner, appropriate orders will follow.
26.
They have to file affidavit in reply. They have to file affidavit in reply, but they didn't file it on last 2 occasions.
This revision petition is against order. Where is the provision for filing this affidavit in opposition and affidavit in reply?
Then just say we need some time to file the rejoinder. So, Lordship kindly examine this matter today.
No, is there any provision in the CFPC?
My senior is not well. Kindly pass.
On that ground, we can adjourn the matter, but for filing reply to the affidavit in opposition filed by the other side.
The case is under Petroleum Act, my lord, and they filed the trial court, they filed money suit, which they cannot file. And in money suit, they filed a delay condonation. So I've never heard the delay condonation application filing the money suit, my lord.
Heart miss, your name please?
Milord,
Your name?
Jayashree Datta.
Learned counsel appearing on behalf of Mr. B. N. Gogoi, learned counsel for the petitioner, and Mr. Roy, learned senior counsel assisted by Mr. Miss, learned counsel for the respondent opposite party. The learned counsel for the petitioner submits that conducting counsel Mr. Gogoi is indisposed of. And as such, rightful listing the matter on some other date. We are allowed basis list the matter after 1 week,
But 12th for hearing, my lord. 12th,
12.
12th for hearing, my lord.
12. Basis list the matter for hearing. Okay.
If they file the reply, okay, my lord, otherwise the lordship will proceed. Item 27.
12, 12, 12 March. March,
March.
Please, your lordship. The second lordship here in this proceeding was we have challenged the proceeding of execution lordship. So 4, 3 and 4 has appeared in last occasion. And 1 and 2 has died lordship before filing this application. So I have filed an application lordship to implead the lordship legal heirs of 1 and 2. So lordship may await for service lordship. I have just Saturday I have filed this lordship.
Yesterday,
Saturday lordship I have filed.
Saturday.
Saturday lordship.
Art, Mr. Kolita, learned counsel for the petitioner. None appears for the respondent number 3 and 4. Mr. Kolita submits that the respondent number 1 and 2 has suffered demise. And he has filed application for
Application
impleadment.
lordship for impleadment only because they have died prior to filing
Yes,
this case.
yes.
So it is impleadment.
He has filed an application for impleadment of the legal heirs of the respondent number 1 and 2, but the same is not listed before this court. And on such count, he pressed for listing the matter after
4 weeks lordship.
4 weeks.
Then
Parallel,
interim order lordship that
this
is
is a list the matter after 4 weeks. Interim order passed earlier shall continue.
lost. I'm deeply obliged.
28.
Please, your lordship. Your lordship, as per office note, it is showing that the service to the sole respondent, it is unserved because of insufficient address. As because inadvertently there was a mistake of, as the pin code was not mentioned in the petition.
Okay. You want to take fresh step?
Yes,
Okay. Heard, Mr.
Arkarin.
Learned counsel for the petition applicant. The learned counsel for the applicant tries for granting him some more time to take fresh step upon the respondent. Fair allowed recessal is the matter after 4 weeks.
Alright.
29.
May I please, your lordship.
Mm.
Lordship, as per the office note dated 20/2026, the steps upon the sole respondent by way of speed force and usual process is awaited me.
So you want to take fresh step?
But fresh statement. However, my lord, whether they have received or not, it has not come.
The postal report is not available.
Yes, my lord. Even by the usual process also, it is not available.
Not available. Take fresh step.
Yes.
Heard, Mr. Sina, learned counsel for the petitioner. Office note dated 20th-2026 indicates that neither service report nor ID card issued to the sole respondent by speed post received back by the registry till date. The said office note also indicates that the process server report has also not been received till date. And the scanned copy of TCR has also not been received by the section till date. The learned counsel for the petitioner submits that he will take fresh step upon the respondent. Accordingly, it is provided that the be taken by speed post and also by usual process within a week from today. Registrar shall also issue reminder to the learned trial court for transmitting scanned copy of the record without further delay. List after 4 weeks.
Item 30. May it please your lordship, may kindly peruse the office note sheet. With respect to the worker number 1, the service has not been completed. The speed post record shows that addressee has left the premises, lordship.
So you want to take fresh step.
Lordship, as well as dusty service, if your lordship permits, lord.
Part is that
HR document.
HR does learned counsel for the petitioner. Mr. Gogo, you are here?
Number 2.
Mr. Gogo for the respondent number 2. Respondent number 2.
Service delivery.
Office note dated 20th to 2026 indicates that neither AD card nor answer notice issued to the respondent number 1 by speed post and also by usual process has been received back by the registry. The learned counsel for the petitioner submits that he may be permitted to effect service upon the respondent number 1 by dusty mode where allowed. After effecting service upon the respondent number 1 by dusty mode, the petitioner shall file an affidavit before this court. List the matter after
Lordship, 2 weeks.
2 weeks.
Lordship, and there is an interim order, lordship.
Okay, interim order pass earlier shall continue.
Right.
May I please notice close to key item number 27, my lord. When the measures called for, I was in another court file. As for respondent,
You give your details to the court master.
31. May it please your lordship, I appearing on behalf of M. Soikia.
Pardon?
Matter sir, transfer petition. Sir,
Okay.
lordship,
Heard, Mr. Your name, please.
S. Millie.
Learned counsel appearing on behalf of Mr. M. Soikia.
Yes.
Learned counsel for the petitioner. Office note dated 20th to 2026 indicates that neither AD card nor unserved notice nor the report of the process server has been received by the registry in respect of service of notice upon respondent number 1 and 2 till date. You take fresh step.
Lordship,
Accordingly, it is provided that the counsel for the petitioner, learned counsel for the petitioner shall take fresh step upon the respondent number 1 and 2 by speed post and also by usual process within a week from today. List after 4 weeks.
4 weeks. God bless you.
Item 32.
May it please your lordship. My lord, as per office note dated 20th February of 2026, my lord. Notice return answered, my lord, with the endorsement, my lord, such address is not available at house number 3. And my lord, report of my lord is usual process, my lord, that has not been received, my lord.
So better you obtain instruction in respect of the actual address.
My lord, this is the address which was mentioned in the, my lord, divorce petition by the respondent, my lord. And we know his permanent address, my lord, but since his address has been mentioned in the, my lord, petition, his address, my lord, that is why we have, my lord, in first title, we have, my lord.
Whether you have mentioned the
Permanent address. my lord.
permanent
Yes,
address
my lord.
in your petition?
Yes, my lord, yes.
Where?
Paragraph 3, my lord. Yes, 3. Paragraph 3.
You take a step in this address
My
also.
my lord.
Heard Mr. Ukedas, learned counsel for the petitioner. Office note dated 20/2/2026 indicates that step taken by speed post upon the respondent returned with a report addressing not available at house number 3. The learned counsel for the petitioner submits that the permanent address of the petitioner is mentioned in paragraph number 2 of the petition.
Paragraph number 3, my lord.
2 or 3?
3, my lord.
Paragraph
Page
number 3 of the petition. And he submits that he may be allowed to take a step in the said address also. Accordingly, it is provided that a step upon the respondent be taken by speed post and also by usual process in the address mentioned in the permanent address mentioned in the paragraph number 3 of the petition within a period of 1 week from today, list after 4 weeks.
My lord, the interim may continue.
Interim order pass earlier shall continue.
Application for my lord, order 41, rule 20.
If notice, we did receive the notice. So there. It's
Notice?
Yeah. Thank you.
Even the respondent number 2, your
The file will be received.
But I'll provide my.
This I is for
As per this is some evidence, madam. Additional evidence, madam.
so you have not received
Objection, my lord.
copy
If they file, then we'll file our objection.
objection.
Yeah, but we have yet to receive the.
And I'll provide my.
Okay. Heard Mr. Khonikor, learned counsel for the applicant. And also heard Mr.
L Deca for respondent number 1.
L. Deca, learned counsel for the respondent number 1 and madam
I mean, for respondent number 2.
respondent number 2. Respondent number 2. Respondent number 2. The learned counsel for the respondent number 1 and 2 submits that they have not been furnished with a copy of the petition. And further, they submits that they may be granted some time to file objection. They are allowed. Mr. Khonikor shall furnish a copy of the petition to learned counsel for the respondent number 1 and 2 during the course of the day.
Tomorrow, madam.
Tomorrow. Within a period of by tomorrow.
By tomorrow.
By tomorrow. Or else shall list the matter. After a week.
We need time to file our. After 3 months.
After 3 weeks. Okay. But this matter is of 2015.
After 2 weeks, no?
After 2 weeks.
After 2 weeks.
2 weeks.
And also the findings, your lordship. It's the concurrent findings.
Okay, we'll hear at the time of.
Diploma.
34.
My lord, IA is for condonation of delay of 18 days, my lord. In
Heard,
filing the
Mr.
K.M. Hassan.
Learned counsel for the applicant. This application under section 5 of the Limitation Act 1963 is preferred by the applicant for condonation of delay of 18 days. In preferring
Civil CRP, my lord. Civil division.
civil revision petition, connected civil revision petition against the order
Against the order dated, my lord. Order dated 22/9/2025.
judgment and order dated 22/9/2022
22/9/2025. Passed by the family court, Principal Judge, Family Court number 2.
by the principal 22/9/2025 passed by the learned principal judge family court number 3 Kamrup M Gauhati in Mizje case number 108 of 2025. Right?
Yes, my lord, Ms. J case number. My lord. 108/2020.
Issue notice to the respondent, returnable in forex,
Lordship may
step by speed post and also by usual process within a week from today.
Lordship may
this of
dusty
the
service
pro-
may also be allowed, my lord. Dusty may also be allowed, my lord.
Okay. Additionally, dusty service is also permitted after effecting service upon the respondent by dusty mode. The applicant shall file an affidavit to that effect before this court.
Lordship, date may fixed, my lord.
25th March.
Public.
Items for admission. At number 9, Parliament.
Lordship, according to the 9th of January, Lordship stated that the advocate, learned advocate general was supposed to argue the matter, Lordship.
Yes.
So in case if the learned advocate general is done with his submission, the Lordship, then will give a rejoinder, Lordship. Today
Pardon?
itself. Lordship, if the learned advocate general is, once he's done with his arguments, Lordship, then we'll give a rejoinder argument, Lordship. Today itself, Lordship.
Okay, all right.
Lordship.
It be taken up tomorrow. One slight clarification I have to take over for, I could not get the officer. Regarding one small, which has arose in my mind, maybe it will come from the court also. So if it can be taken up tomorrow, Lordship.
Tomorrow.
Tomorrow at 2, your Lordship, because some matters before a division bench is there.
In that case, then day after tomorrow, Lordship. Because Lordship is quite fast, so no point of waiting till 2 o'clock. So day after tomorrow, Wednesday, it will be a motion day.
Lordship.
Okay. As agreed by learned advocates of both the parties, recessal is the matter on Wednesday.
25th.
So to fix a time,
And it will later come in on regular course.
regular course. Okay.
Lordship.
Okay.
Only one clarification, because the number of posts was increased from 7,000 to 11,000 and some state pool issues were involved. That's some clarification. I'll take it over phone.
Lordship.
Highly obliged, Lordship.
Lordship.
17.
May I raise a motion? My lord, this matter, in the meantime, they file their affidavit. We will file objection. 4 weeks time may be allowed. In the meantime, we will file the objection.
This is a civil revision petition against an order. Is there any provision in CRPC for filing affidavit in opposition and affidavit in reply?
I have to see, my lord. Usually we file. In the meantime, we have to take some instruction from our client, my lord.
Lordship, it's a very interesting case, Lordship.
Hmm.
Judgment has been passed in 2022, no appeal has been preferred. Decree, we have put our decree in execution on 2023.
Hmm.
Suddenly they have come up with this petition, Lordship, without challenging anything.
No, whether delay was condoned or not.
No condone,
No delay, nothing
stays
else, Lordship.
there.
They have challenged one execution case without
Okay.
challenging anything.
We come
Our
for-
decree, they have not filed any appeal against that decree. They are contemplating to file an appeal. That we will file an appeal, and till then we should be protected. And that appeal is of 2022. Lordship, just Lordship can look at the synopsis part even. Last paragraph of the synopsis part.
Hmm. But
That petition, Lordship.
no, that's all right. I'm ready to hear the argument, but he is not ready.
No, they are dragging, they have obtained a stay order, Lordship.
They are waiting from 2014, my lord.
No, question of not waiting,
For which
question of
nothing more,
procedure.
my lord.
Hmm.
Incorrect, Lordship.
We,
Because without preferring any appeal And para 11 Lordship, if you
We came only for
page 12
against
Lordship,
execution, my lord.
page 12 Lordship, para 11. Page 12 of the petition Lordship. Para 11, may I read Lordship? Once the petitioner states that they would prefer a title appeal against the judgment and decree passed in title suit number 14. And aforesaid, as such, the proceeding of title acquisition be stayed and suspended till disposal of the appeal, that would be preferred. Nowhere the scope blocks it.
Okay, let us fix a date. Bobby,
I have filed this state vacation petition, that's why, because our decree has been stored. Maybe disclosed today, Lordship, it's the.
Oh, my lord.
Where is-
Last date also, they have
Only
taken
we
that date.
come
no,
against
no,
the
where is the
execution
vacation
order, my
petition? Where is the stay vacation petition?
IA is there, Lordship.
Correct.
IA petition is there, Lordship.
my lord. They have purchased 10 acres of land from 2 person, my lord. From
Let them check.
different two boundaries, my lord. In execution case, they include the 5+1, 5+I include in
Okay,
both.
Bobby. We will grant you 2 weeks time. If you fail to argue the matter, we will vacate the interim order next day. Today we will issue notice in this I. Heard Mr. Pudra, learned counsel for the applicant. And also heard Mr. Your name,
View Ahmed.
learned counsel for the opposite party. This interlocutory application is preferred by the applicant for vacation, modification, alteration of order dated 29/8/2025. Passed by this court in CRP IU number 349 of 2025. Issue notice. However, no formal notice is required to be issued since Mr. Ahmed entered appearance and received notice. However, extra requisite copy of the petition be furnished to him during the course of the day. List the matter on 13 March. In main CRP, you take down heard Mr. Ahmed, learned counsel for the petitioner, Mr. Putra for the respondent. Mr. Ahmed submits that he may be granted some time to obtain instruction and to file affidavit in reply. They are allowed. Last opportunity is granted to the learned counsel for the petitioner. List the matter on.
All right.
Item for hearing and order.
Obliged, my lord.
Item 19.
May it please your lord. My lord, in this case, last champion order, lordship will find page 81. Annexure I, my lord. This misappeal was also dismissed, my lord. My lord, here the respondent filed, my lord, title suit, my lord. My lord, impeding this petitioner and another one, my lord. And thereafter, that title suit was expired. By an expiry order, it was, my lord, allowed. Thereafter, my lord, this petitioner filed an application for setting aside the expiry order. That application also rejected, my lord, and thereafter he filed a misappeal, my lord. That was also dismissed, my lord. So against this, my lord, this second appeal, my lord.
Which is the impugned order?
Lordship, page 82. Start from page 82, my lord.
82.
Yes. In this case, my main contention is that I have not received any summons. But from the record, my lords, it is found that the brother of the petitioner received the summons. But my question is that since I am my lord, soldier, I was serving my lord, out of my Assam, my lord. So service has to, my lord, as per my lord, Order 5, Rule 28. It has to be through court, my lord. But that
No, Mr. Uddin, you see,
Lordship.
in the last part of the impugned order, it has been observed that the appellant, page number 96,
Lordship.
the appellant admitted his address and his brother who received the summon at that particular time.
Yes, my lord. His brother received summons.
Yes.
But my case is that my lord, my brother has not informed me, my lord. And as per my lord, procedure, my lord,
background.
when he is, my lordship, my lord, another notice, lordship. Lordship, may kindly see. I have annexed the report also, my lord. That is, my lord, 107 is the report of the, my lord, this notice server, my lord.
107.
107, my lord.
Yes.
My lord, just it is hereby submitted that due to my ill health, I could not serve the notice in due time, hence submitted the notice to the court answered. Prayer that further date be fixed by the Honorable Court for service. Justice, the submission is that on today, that is 11/3/2004, at approximately 3 o'clock, on my own inquiry about the above written address of the above mentioned opposite party, but could not find the above mentioned opposite party, but found the elder brother of the opposite party, I informed the matter to him and requested him to receive the summon. And he accepted the same and put his signature as witness. And at the time of execution of the notice, the witness were also present. So, my lord, the process server requested his brother, and accordingly, his brother received the summons. Lordship, may kindly see another notice, my lord. I have annexed.
No, whether service of notice to the brother is not service of notice to the petitioner? The appellant herein?
Yes, my case is that, my lord, since I was serving, I am serving as a military person, my lord.
As a?
Military. Soldier. He is admitted, my lord, in the cell deed also his address is given, my lord. So, service has to be served in his, my lord, office address, my lord. As per order, my lord, 5 rule 28, my lord. Lordship, may kindly see, my lord. Order 5 rule 28.
Order 25.
My lord, order 5, rule 28.
Yes.
My lord. Rule 20, service on soldier, sailor, or airman. Where the defendant is a soldier, sailor, or airman, the court shall send the summons for service to his commanding officer together with a copy to be retained by the defendant.
Which part you were reading?
This order 5 rule 28, my lord. Of CPC.
Where is the petition?
My lord. My lord, that petition is, page 41 is the petition, my lord. For initial setting aside the ex parte order. And that order also, my lord, without framing any issue, my lord, it's just.
So where you have given your address, service address?
Lost. My lord, my service address is my sale deed, my lord. My sale deed, my lord, which was challenged before the, my lord, in title suit. And that sale deed is lost, may kindly see. I have
Page
annexed.
number?
Sale deed, lost, we will find page, my lord.
Page 98, my lord. My lord, in favor of Nijamuddin, son of Najimuddin, resident of village Singarborn, part 4, Paragana, Ruparbali, PS Lakhipur, district Kachar. And this in the title suit, the address is not as per this deed, my lord. And it is also mentioned, my lord, my profession is government servant.
Maybe your profession does not matter here.
But admittedly, he is a soldier, my lord.
Maybe.
He retired.
Here, your address is at the address mentioned in the petition. Hmm?
My lord, the address mentioned in the petition is, my lord, resident of part 4, PS Lakhipur district. Yeah. But in title suit, lordship will find address is, I have annexed the title suit, lordship will find page, my lord, 14. Lordship may kindly look, my lord. Page 14 is the address of initial title suit.
Page?
14.
Page?
14.
Yes.
Defendant number 1, Lahiman Bibi, second, my lord. Nijamuddin, son of Nijamuddin, aged about 40, Singarbon, part 1, village post office, Dulogram, Paragana, this Rupari Valley. So address is also not same, madam, with this value.
But you have admitted that
there is admission, my lord, his brother received.
your brother received the summons.
But my case is that brother are residing separately, my lord.
No, that cannot be a ground.
But so far, my lord, this provision is a law, my lord. Order 5, Rule 28, my lord. Since he is working in the, my lord, army, so court has to, my lord, issue someone on that address.
No, where that address you have mentioned?
My lord. That address is in the sale deed, which was, my lord, there wrongly, my lord, this address has given wrong address. I have mentioned in my petition also.
Okay, we'll see.
My lord.
Orbit, separate. Kita pergilah. None appears for the appellant on call. List the matter after 1 week. In the event of subsequent non-representation of the appellant, appropriate order shall follow.
Standing item 23 and 24. You
23 and 24.
Pending cause. Assess ignorance in opposite party. Opposite party assess ignorance. Control control Malmun publish. Malmun performance necessary for the government advocate আছে secondary education আছে like 22
Sector.
আবার পঠাই দিন বলে পড়ে Let me enter that. Yes, let me get that
Leave can be granted. You have no objection.
No,
I've heard so, my lord.
Heard Mr. A.K. Sharma, learned counsel for the applicant. Ms. D.D. Burman, learned additional senior government advocate for the opposite party number 3, and Mr. Mehdi for opposite party number 4. None appears for the rest of the respondent. Though on earlier occasion, their engaged counsel entered appearance. Mr. Sharma, learned counsel for the applicant, submits that the applicant herein have not been arrayed as a party, no, as a respondent in the WPC number 632 of 2024. And that in the said writ petition, respondent number 5 yes, you are appearing here in this interlocutory application as respondent number or respondent number 1, 2, and 5. 1, 2, and 5. The respondent number 5, the inspector of school, who was holding the charge of principal of Amaranga Barihat Higher Secondary School, was directed to issue non-royal certificate to the petitioner within a period of 1 week from the receipt of certified copy of this order. Certified copy of that order. So Sharma further submits that it was also directed that 25% of the retirement benefit of the petitioner shall be held up till resolving the dispute of expenditure and utilization certificate by the respondent authorities with the petitioner. And only after resolving the dispute, the remaining 25% of the retirement benefit shall be released to the petitioner. Mr. Sharma further submits that the present applicant, that is the School Management and Development Committee, Amaranga Borihat High School, has to issue the NOC.
Yes, my lord.
Has to issue the NOC. And that a sum of rupees, what is the amount to be adjusted?
My lord, as per my lord, our calculation, almost 20 lakhs, my lord, more. Almost 20 lakhs, my lord.
20 lakhs.
Irregularities, my lord.
No, in your application, where you have mentioned it?
My lord.
15 lakhs for your lordship.
No. He has some amount to return, some amount to be returned to the school management committee. Where you have mentioned it?
No specific, calculate, we have not stated here, my lord. But my lord, as per my lord, that audit report, my lord, that calculation is come, my lord.
Oh,
We
what is the amount as per audit
As per
report?
my lord calculation, my lord, almost 20 lakhs, my lord.
Almost 20 lakhs.
Yes, my lord.
Submits that.
It is page 7 of review petition, page of 6.
My lord, in that review petition, my lord.
22 lakhs, 42,000.
My lord, that's a review petition, my lord, not before you, not
Okay.
registered till now.
And as per his instruction, is sum of rupees 20 lakhs has to be returned by the respondent opposite party number 7 herein to the school management committee. And even if 25% of the retirement benefit is held up, then the same would not be sufficient to adjust the amount which the respondent number 7 has to return to the school management committee. And since the school management, no, since the order dated 24/9/2024 was passed in absence of the present applicant, the present applicant has filed a review petition and the same decided to file one review petition and to file the same leave of this court is required. And as such, he contended to allow this interlocutory application, granting leave to the applicant. You have any objection? No.
No.
The learned counsel for the respondent opposite party number 1, 2, 3, 1, 2, 3, 4, and 5 submits that they have no objection in the event of granting leave to the applicant to prefer the review petition. Accordingly, taking note of the submission of learned counsel for both the parties, this interlocutory application granting leave to the applicant to file the review petition for review of the order dated 24/9/2024 passed in WPC number 632 of 2024 within brackets since dispose of stands allowed. Now, the registry shall register the review petition and list the same before this court as soon as practicable, preferably within a week.
My lord, notice has already been served, the petition has already appeared, my lord. So, my lord, regarding.
No, review petition is yet to be registered.
No, yes, my lord, but my lord.
We have to issue notice in that review petition.
Yes.
Finding item 1 for motion. Item 1.
None appears for the applicant on call, list the matter after a week. In the event of subsequent non-representation of the applicant, the appropriate order will follow.
For hearing, item 35.
Okay,
Notification.
okay. Madam, perhaps you have obtained one report regarding who is the owner of that motorcycle, first motorcycle. You have submitted the same before this court
Yes, Lordship. In earlier occasion, Mr. and submitted.
earlier occasion. কিবা লিখা আছে নেকি?
আছে নেকি?
কিবা ৰেকৰ্ড কৰা আছে নেকি? নাই ন?
আছে কোৰ্টত দি।
Okay. So one option is we can direct the SIT to take up this matter. That is one aspect. And another aspect, we can set aside the impugned judgment and award and direct the tribunal to proceed against this motorcycle also,
Yes, sir.
owner of this motorcycle also,
Also implicate them.
including the present.
Present. The implicate just addition, one more party has to be added.
Yes. Yes, Mr. Khan, on the other day, you want to submit something?
My doctor, my submission has already been, I have given a detailed argument along with the citation lordship. My submission is that while lordship evidence shows the involvement of the vehicle, only because of some discrepancy the GD entry cannot be given weightage to that. Because evidence is very much clear. Owner and the driver of the vehicle has not disputed. They admitted the fact. They have lordship submitted. They have filed a written statement. They did not deny. And so far, lordship, the Honorable Supreme Court decision is concerned, lordship, that I have given. Lordship, while the insurance company lordship has not made any complaint before the higher the police authority, or they have not challenged the FIR or the charge sheet. So now they cannot take that.
No, Mr. Khan, you see, this allegation of fraud that can be raised any stage of the proceeding, be it trial court or in appellate court. So the principle is that fraud vitiates everything.
But whether it is fraud or not, that is to be established. In fact, lordship, the GD entry was also not fraud. Because who has endorsed the GD entry and who has given the information?
No, original GD entry is before this court. We have checked it. We have found the discrepancy.
No, these persons who has given the information and who has endorsed the GD entry, these two persons has not been examined. Only IO of the case is examined.
Yes, he is the person who had taken the vehicle to the police station.
That is that part he has explained that on assumption he has
Assumption, can there be an assumption?
subsequently on thorough examination he found that another vehicle was involved, that he has given the after that he has submitted the charge sheet. Only on example that it was, it may be fraud.
No,
So
not
while-
presumption,
while-
the materials
while
available
evidence
before this
can-
court shows that something is wrong.
But while the evidence, it is before the tribunal, in respect of the claim case worship, sufficiently established the case that the vehicle was involved. Now it is up to your lordship. My submission already I have to give a lordship. Because the case is lordship very old.
Maybe all, but if we allow this kind of things to go on, then it will send a very wrong signal.
But this is the case of 2015. More than 10 years. If your lordship remand this matter, again it will take time. पहले से 20 plus 11-12
You can was direct. Direct bidding was
No, no, ये तो लोग से है no? 1980. Okay. ये तो original number है.
Madam, in this report regarding that vehicle, nothing is mentioned about the insurance company.
It is only like that the computer that interest affected lordship.
That may be the reason.
The owner is there.
That may be the reason for planting another vehicle.
Yes, that's
That may be the reason. Anyway,
lordship, I think lordship that the earlier lordship, the scooter lordship that scooter has no insurance coverage lordship.
Okay.
That's why after lordship that this was implanted lordship.
that is
That is
yes.
lordship. In the most of the MSC case lordship now it is going on. The accident is by other vehicle, but after that lordship that another vehicle is lordship. And they are in.
Okay,
Yeah,
on
how
this
can we-
ground, we will set aside the impugned judgment and award.
That vehicle was not insured.
Pardon?
But in the database, there is no name from the insurance company, no? That is.
Database. She has obtained one report earlier
Yes.
from the DTO.
Yes.
There, nothing is mentioned about the insurance company.
I have not given any submission.
But lordship, this has become quite rampant. This kind of, he have become very rampant nowadays.
Yes, Lord.
Yes.
Recently, lordship, if I may just to point out, I have given my opinion in two cases. One of the cases was settled in the low court lordship. After it was found, their lordship, this matter has reached the high court also because an officer of the company was also involved there. Someone was forged the signature of the manager. When it is found that the moment that was spotted, tribunal records were just set, was taken out. But a copy was sent to High Court. That this claim has been settled. So that is after that lordship, company investigated the same advocate, two different advocates in the trial court, but High Court advocate was the same. It is found out. I know it because my opinion is taken. Both the cases are completely false. Police station records, CJM records, PS, everything is false. And in one of the cases, when the investigator went to the house of the claimants, in two cases,
In one case, the husband is still alive. It was the case for her, the death of the husband. Husband is still alive. And in the other case, the husband had died for a year from kidney disease in Dibrugarh. So to this kind of, I said, it's happening at a rampant pace. These are very recent cases. On the last month, they filed a FIR against all the process.
Some rackets are going on.
Yes, sir. It's quite rampant.
And have you noticed that cases from all over Assam are being filed in Kamrup?
Yes, sir.
Okay, we'll pass the order. Okay.